Did counsel get the letter that I asked the marshal to give you all?
Yes, Your Honor.
All right, thank you.
Morning. How are y'all this morning? All right, we'll wait to let you get set up. Sure you're comfortable? Looks like you're ready to go.
Ready.
All right, let's go. Call the case. You know what it is. All right.
May it please the court. My name is Andrew Graham. I'm an attorney from Melbourne, Florida, and I represent the plaintiff, Kate Murphy Adams, in this case. This is a direct appeal from Circuit Court, 18th Circuit in Vieira. The final order that was entered in this case was entered on a motion for rehearing, which was actually a motion for reconsideration, of an earlier order which had denied motion to dismiss under Rule 1.420E, the LOP rule. The motion for reconsideration was held in July of 2006, and Judge Barlow reversed himself and granted the motion to dismiss. And this appeal followed. The issue arose, the issues which are before the court today are whether or not the rule which went into effect on January 1st, 2006 governed what the judge should have done below, or the earlier rule which was in effect prior to that date governed this decision. Number one. Number two, whether there's any record activity. Number three, whether there's sufficient good cause of non-record activity to avoid the LOP dismissal. Those are the three issues. In regard to the issue of the date of the rule, the LOP rule has given the state, the lawyers, the judges of the state, headaches and toothaches and everything else for many, many years. The Supreme Court was clearly engaged in an effort to simplify and ameliorate the harsh effects of the LOP rule. In November of 2005, the Supreme Court handed down Wilson versus Sullivan, which created the bright line rule as to record activity. At the time that case was sent out here on the seas of the law for us to understand and read, they were also at the very same time considering changes to the rules. One of the changes they were considering at that time, they adopted, and that was to the rule 1.420E, the LOP rule. And that change, which went into effect on January 1st, 2006, or just about 6 or 7 weeks after the Solomon case came down, allows the plaintiff, when called to the attention that he has not done anything in the case, to cure his failure.
Did you argue the new rule below?
Here's what I did below. I didn't get a chance to argue until 18 pages into the transcript of the hearing on April 11th. The very first words out of my mouth, and it was clear when it was my turn to talk, that the judge and the defense attorney were arguing the old rule. It's clear. The very first thing out of my mouth was, the rule changed January 1st, and under the new rule, we cured because on January 4th, the day we received the LOP motion, we filed a notice for trial, and thereafter went to a scheduling hearing, and I think we may have, I'm not sure, we may have even disclosed experts. I'm not sure about that, but we did clearly cure the defect under the new rule. The very first thing I said to the judge was, the rule changed, and under the new rule, we cured. Thereafter, I argued the old rule because it was obvious to me that that's what the judge was going to consider. And we had also filed the requisite affidavit within the period provided by the old rule ahead of that hearing.
Did you tell them something to the effect that, if they had filed this thing on January 2nd, we wouldn't be in this predicament?
I did tell him that. Apparently, that's what the transcript says. I told him.
Wasn't that kind of a concession that the new rule did not apply?
Well, I'm not sure that I even had the ability to concede that. Did I say that so it looked like a concession? Apparently I did. That's what the transcript says, although it says it after I pointed out that there was a new rule and that we had cured under the new rule. And it was also obvious to me that this is what we were going to be arguing, that it wasn't going to do any good to argue the new rule.
If the new rule does apply, does it make any difference whether you argued it or not?
Yeah, that's the other question. I'm not sure it's waivable. if it went into effect on January 1st, 2006 for everybody, all the parties in the court, and that's the rule of civil procedure, then that's what should have been followed. And if I'm too dumb to get up there and argue that rule, then I don't think that necessarily I have the ability to waive it. That is the rule that applies. That's what the court should apply. That's one way of looking at it. I don't know that that's the case. But it seems to me that I brought it to his attention, pointed out that we'd cured under it. Later on at the second hearing, I also once again reminded him that that had occurred. And if I misapprehended the fact that and assumed that there was a vested right to have the case dismissed under the old rule because it was filed 2 days before the new rule went into effect, that's my bad, I guess. I mean, I don't really know how to say that except to fess up and say yes. Apparently, that's what I said. Did I waive it? I brought it to his attention. I gave him an opportunity to look over, to think about it. It was clear to me that it was not going to be argued. What was going to be argued was the old rule, and I argued the old rule, and I had prepared to argue both of them. And it was pretty obvious 18 pages in the transcript when I finally got to talk. That's what was going to happen, so that's what I did. So to answer your question, I don't know if I answered your question, but I hope I did.
You did.
The way the first thing, of course, I argued was that there was record activity under Solomon versus Wilson because there was a docket entry.
When was the motion filed?
The motion was filed on December 29th. December 30th, 2005.
Okay. And the new rule became effective according to the Florida Supreme Court's opinion that adopted it on January 1st, 2006.
Right, 2 days later.
But is it your argument that simply because a decision hadn't been made, although the motion had been filed in the time period when the old rule clearly applied, that was enough to get you in under the new rule?
Yes, that is my argument in the sense that the litigants are bound by the rules at the time they file their pleadings. So it's clear that the litigants who filed the motion correctly filed it under the new rule, under the old rule. But the court.
Then why wouldn't that be the date that the court would consider as to what rule should apply? Obviously, the new rule didn't become effective until January 1st.
Yes.
The motion was filed before that. Why wouldn't that be the effective date to make that determination? Because
the court exercised its jurisdiction on April 11th, 2006. The exercise of the court's jurisdiction is different from when the pleadings were filed. So I maintain that when the rule changed during that interregnum between the filing of the pleadings and the exercise of the jurisdiction, the court is required, when exercising its jurisdiction, to exercise it in accordance with the rule in effect at the time.
You're saying the court did not have jurisdiction in December when the motion was filed?
The court had jurisdiction, but it did not exercise its jurisdiction until the hearing.
So you're saying then that the key is even though the court has jurisdiction, the motion's been filed under the time period when the old rule applied, that it's the exercise of the court's jurisdiction?
Yes, that's what I'm saying. And that's what I think Whitaker versus Eddy stands for, that proposition, which is an old code pleading case. You have to read it carefully, but
does that case specifically apply to a rule that was adopted by the Supreme Court opinion that gives an effective date with a motion that's to be heard that, filed prior to that?
It applies to a rule of practice and procedure which was adopted by the legislature under the code pleading rules back in the 1930s.
Okay, and was there an effective date that was provided, in the rule as to when it became effective?
I believe so. I believe that, in fact, Whitaker versus Eddy says that at the time you file the pleadings, that you have to follow the rules in effect then, but at the time the court has the hearing or exercises jurisdiction, it must follow the rule in effect then.
Mr. Graham, there are a couple of cases cited by the appellee, specifically Betts and Metcalf, that seem to me to be pretty relevant, but yet they were not addressed in your reply brief.
Well, yes, Your Honor, I understand. It seems to me that the broad principle of law here is summarized. I did a notice of supplemental authority on a case that came down out of the fourth in January of this year. The name of that case is...
But that was a revision in case law, wasn't it?
Yes, but it seems to me that since the rulemaking authority does not permit the creating of substantive rights, I'm arguing the other side of the coin from the earlier argument here, that in fact this is a procedural right or procedural procedure that was done by the Supreme Court. Therefore, it affects, seems to me, everything pending forward. So I would argue that those cases, which were cited by Appellee, do not stand for the in fact, the argument is that once the motion was filed and the rule in effect at the date the motion was filed governs all the proceedings from there until the case is over. That's the argument of the Appellee. My argument is no, that's not true. When the rule changes, then the new rule governs the proceedings from the date of the change forward. And I would argue the Eddy case.
Isn't there an exception that says if there's a specific effective date that's provided? That, I mean, that's.
I understand that argument. What that means to me, though, and what I think it means to a lawyer arguing my side of the case, is that means that all cases pending on the date will be governed by.
In your particular case, the 1 year had expired before the new rule became effective. The motion was filed before the new rule became effective.
Right.
Everything that they could have done was done before the new rule became effective, except have a hearing on the motion that was filed at the time the old rule was in effect. Yeah,
interesting issue. I agree. That's a completely interesting issue because you don't often. I've been doing this 31 years. I don't think I've ever had a case where the law changed between the date of the motion.
It seems to me that it's clear that the old rule would apply.
I think that Whitaker versus Eddy says to the contrary, but that's we can disagree about that.
Okay.
All right.
Your right to cure was established by the new rule.
Yes.
So what you're saying is that when you filed your whatever you did, a notice for trial, in order to avail yourself of the cure provision, the new rule, you filed it pursuant to the new rule because it was filed after January 1st.
Yes. That's exactly what I'm saying, and therefore cured the defect. So
that really the issue is, did you have the procedural right to file to cure after the new procedure came into effect?
Yes, that is exactly the issue. We clearly did cure. There was never any dispute about that, and there isn't any under the new rule, which I'm not sure. It did go into effect 12:01 a.m. on January 1st of 2000.
What happens to the old rule? An old procedural rule. You know, what is the legal effect of that? Of the enactment of a rule that supersedes an old procedural rule?
I would argue that all cases pending in future cases would be governed by the new rule.
And the old rule evaporates or is no longer a valid rule?
Yes, it would end as of 12 o'clock midnight on January.
So doesn't the opposing party have rights under the old rule?
Well, that's the question. Are there vested rights? Is there vested rights to a dismissal under the old rule that can't change?
It seems to me then that I have a hard time following the concept or the notion that, you know, when everything was done under the old rule, except having the final hearing under the motion that was filed under the old rule, and simply because there's a new rule that's adopted that you subsequently try and seek relief under doesn't necessarily relieve them of their rights under the old rule. And if the trial court had a hearing under the motion that was filed under the old rule and made a decision on that, does that therefore give you a right to come in under the new rule and seek a different relief?
Well, I did bring the new rule to the attention of the trial court. So if it should have ruled under the new rule, I don't believe that I waived that issue nor could have waived that issue. But to try to answer your question, if there are vested rights under the old rule and therefore the new rule does not apply, then I couldn't cure. I guess it would be the old rule would apply, and we would argue the old rule, which in effect we did argue. The judge then ruled that I showed good cause for off-record activity and denied their motion to dismiss and then changed his mind on reconsideration in July later that year. But
Do you have any argument to make with respect to the Betts case?
Your Honor, I'm going to confess ignorance on the Betts case because off the top of my head I don't exactly know which one that is. So I don't have a specific argument to the Betts case. But the Saya case, which is kind of an interesting case, the Saya case, which the Supreme Court said the 30-day rule to file your motion for attorney fees and costs is hard and fast 30 days. Just by filing a reservation of jurisdiction doesn't extend that anymore. That's an interpretation of a rule, and in that case, the Fourth DCA interpreting the Saya case said an appellate court is required to apply the law in effect at the time of its decision, applying the 30-day hard bright line test in Saya, and then cited a series of cases that stand for that proposition. I would argue that the same principle applies to the trial court. To exercise the jurisdiction, it must do so in accordance with the law at the time it exercises its jurisdiction. In the law, rules of practice and procedure, in my view, were the new rule in this case. I would like to say a bit about the record activity. The judge found that the computerized docket entry dated the 3rd of January of 2005 was not record activity. In Solomon versus Wilson.
Mr. Graham, is it that it's, I read his findings,
Yes.
but is it that it's not record activity, or is it that he knew that it was an error because he had the date stamp on the motion to dismiss, and that preceded the, the erroneous docket entry?
It wasn't an error. It was an automatic function of the court's computer to keep rolling that date based on the earlier scheduling conference that had been had months and months.
But I noticed on that docket it didn't reflect the filing of the motion to dismiss. Right? I mean,
the document, which was the register of actions, which was attached. Well, of course, because the date of the right, that it wouldn't reflect that, because the date of the calendar entry was January 3rd, 2005. The date of the motion to dismiss was December 30th, 2005.
Oh, it was that.
Right, at the end of the following year.
3 minutes left.
Just briefly, in Solomon versus Wilson, the Supreme Court said the bright line test now for record activity is filing of pleadings, orders of court, or otherwise. What the heck does or otherwise mean? A couple of dissenters in that opinion had the very same problem with what or otherwise means. This is not an order of court. It's not a filing of a pleading. The docket entry for the trial date of January 3rd, 2005. I would argue that it's an or otherwise. In other words, what Solomon versus Wilson was designed to do was to prevent the judge doing exactly what he did, looking behind that entry to find out what that meant. He says it's an automatic computerized roll forward thing. I don't dispute that. I have no reason to dispute that. But I would say that the or otherwise language eliminates that the judge not do that, tells the judge not to do it. Just look at it. There's something on there. That's it. That's enough record activity. We're going to deny it. Knowing full well, of course, they had the cure provision getting ready to go in effect 6 weeks after the came down.
Does that line entry coincide with some document that was actually filed in the court file?
It does, but the document was filed much earlier after the scheduling conference when the judge set the trial date.
Dates were on there, and it just now
Right,
pops up.
and every time something was entered, then that roll became the next date. I think that, and I'd just like to say by many times, thank you.
May it please the Court. Angela Flowers on behalf of Frank Copeland. Also seated at council table is Kendall Rigdon on behalf of the co-appellees, the Shepherds. There are 3 issues which we are examining today, and I'll take them in order as appellant did. Beginning first with the question of whether or not the amendments to Rule 1.420 can be applied retroactively. I'd like to rely upon 2 cases from this Court, the Betts versus Ace Cash Express case, in which this Court examined the proposal for settlement rule, Rule 1.442, in which an amendment occurred that provided for an extension of time for the response to a proposal for settlement in a class action case. And in the Betts case, the proposal was served upon the plaintiffs under the old rule, which provided only 30 days to respond to proposal for settlement. During the pendency of the case, the new rule came into being. Not until after the new rule had been enacted was the motion for attorney's fees filed and the hearing on the motion for attorney's fees. And as this Court held in the Betts case, rules of procedure are not to be applied retroactively. They are applied prospectively only. This is a black letter rule of law, and the only exception to this rule is when there is a provision in the amended rule which provides that the rule will be applied retroactively. So in this case, despite the fact that the motion and the hearing were held after the rule amendment, this court recognized that you go back and that you apply the rule that was in effect at the time of the triggering event.
So the difference between Betts in this case is that in the instant case, the time limit had expired and the motion had been filed before the new rule became in effect. And in the Betts case, that was done essentially after the new rule became effective.
Right. The Betts case is a more extreme example, and certainly if this court was going to apply that rule in Betts, it would apply here. Our current case is much more like this court's decision in Erickson versus Breslov, in which this court noted in footnote 1 of that decision, in applying this exact rule, Rule 1.420, that it would apply the version of the rule that was in effect at the time the relevant events occurred. And the irrelevant events under Rule 1.420 are the calculation of the 1-year period for lack of prosecution.
Well, it's not clear in that case that,
Go ahead.
it's not clear in that case when Judge Evander says in that case all relevant events that occurred, it's not clear when the hearing was actually conducted in that case.
We fall somewhere in between the two. In Erickson, it appeared that the motion was clearly filed before the amendment. It also appeared to me in Erickson that the hearing occurred before the amendment, and in fact the appeal was taken in Erickson before the amendment. So it was much clearer, of course, in Erickson that all the relevant events had occurred prior to the amendment of the rule, but nonetheless, reading Erickson and Betts in conjunction, and Betts being more like our case, in which the hearing is held after the amendment of the rule, I believe that Betts will control, and that in this case, the court follows the black letter rule that amendments are applied only prospectively, unless there's some provision within the rule that would instruct the court to apply them retroactively.
Let me ask you this, Ms. Flowers. Why isn't a relevant event here the prosecutorial action within the cure period? In other words, in this case, they filed a notice for trial. Why isn't that a relevant event, number one, and why aren't they entitled to, in applying the rule prospectively, why aren't they entitled to file that pleading under the new rule?
Under the plain language of Rule 1.420, it indicates that the decision of whether or not the court will dismiss for lack of prosecution, and the rule, remember, is mandatory, shall dismiss, that determination is based upon whether at the time of the filing of the motion there had been 1 year of lack of activity. So we don't look to see what events occurred after the filing of the motion. It just doesn't become relevant under the rule as it's written, because the only time period that the court is to look at in making that determination is the 1 year, looking at the date the motion was filed and going backwards for 1 year. If I can also touch upon this question of whether or not there was any record activity, not referring to the filing of the notice of trial, but the fact that there was appearing on the register of actions an entry that the case had been scheduled for jury trial to begin on January the 3rd of 2005. I'd like to just point out to the court that when you look at the registry of actions, it says on the face of the registry that this calendar posting occurred on March the 23rd of 2004. And as was discussed earlier, what happened was there had been an earlier calendar call at which trial had been set for this January 2005 date. And this was just a pre-calendaring of the trial event, which occurred back in March of 2004 at the time that the clerk noted that the case was going to come up for trial a little over a year down the road. So there was no actual activity that occurred in January of 2004. The actual, even the physical entry into the computer.
What does or otherwise mean?
There hasn't really been a
If you want to go under the old rule, what does that mean then?
there hasn't really been a good definition of that that's come forth in the case law, and there is some indication that that's.
Why would that be an or otherwise?
Well, the reason it wouldn't is because, as I just pointed out, even if you look at this entry, which is on the docket sheet, on the face of the docket, it says that the activity involved, the entering of this calendar notation for jury trial, occurred back in March of 2004. So there wasn't any activity. So even if there was an or otherwise, and even if you looked to see if there had been any activity which would qualify as the or otherwise, that activity would have had to occur within the 1 year period that we're looking at. And on the face of the docket, it reflects that the activity here occurred back in March 2004, over a year and a half prior to the period that we're examining. Counsel for plaintiffs did not have a chance yet to discuss the third issue in this case, which has to do with what the trial judge faced once he determined that the rule that was in effect on the date the motion was filed was going to be applied, and then the trial judge determined that there had been no actual record activity for the 1 year period prior to the filing of the motion to dismiss. The trial judge then was called upon to look to see whether there had been any non-record activity, which the plaintiff could rely upon and make a good cause showing as to why the case should be permitted to continue. Now, plaintiff asserted below that they had contacted opposing counsel to request an extension for the filing of better answers to interrogatories. However, plaintiff acknowledged below that this contact with opposing counsel occurred before the 1 year period that we're looking at. The plaintiff had obtained a court order on December the 6th of 2004, which permitted them to file better answers to interrogatories on December the 20th of 2004. They wanted an extension of time. They contacted opposing counsel, and there was a letter December the 21st of 2004 confirming that an extension had been granted until January the 4th of 2005. So we have a phone call and the confirming letter on the 21st, and then 8 days later, December the 29th, is when we have the last record activity shown in this file. There was no further contact between plaintiff's counsel and defense counsel between the date of the last record activity.
Let me kind of switch subjects just a little bit. Once the year had expired and you filed your motion during the time period when the old rule was effective, did you have a vested right to have that motion heard under the old rule and to have the case dismissed under the old rule?
I'm not sure that I would use the term vested right, but it's certainly a right under the rules of procedure in effect on the date that the motion is filed. Now, to me, when we start talking about vested rights, it gets more at a higher level, or perhaps...
Well, the reason that becomes of interest is because there are plenty of cases that say that when a statute or rule is to be applied prospectively, it's inappropriate to do that if it's going to cut off vested rights.
Well, I suppose the fact that the Florida Supreme Court has stated that it's a black-letter rule of law, that our rules of procedure are going to be applied prospectively only, implicit within those holdings by the Supreme Court is the concept of a vested interest.
But here we have a rule that gives you a specific date when it becomes effective.
Correct.
And so it seems to me like that has to mean something, and it gives you a specific date as to when that rule is going to be applied when it becomes effective.
Correct. I think that answers the question completely. You know, a decision adopting the rule specifically says the effective date is January the 1st of 2006, and this motion was filed prior to that date. So we don't have a decree from the Florida Supreme Court which says you can apply this rule any time prior to what is set forth as the effective date, which is January the 1st. Continuing along with the good cause showing, in reviewing the trial court's decision as to whether or not plaintiff made a good cause showing, we review this decision under an abuse of discretion standard. All of the other issues have been de novo review because they've involved questions of law and application of the rules. But now we switch to a review under the abuse of discretion rule. Plaintiff is claiming that their unilateral activity of having prepared better answers to interrogatories is sufficient to establish good cause. Now, good cause normally requires contact with opposing counsel. This unilateral activity of preparing these answers to interrogatories did not involve any contact with opposing counsel. In addition, good cause also involves some type of conduct geared to moving the case forward. Because plaintiff never served nor filed the better answers to interrogatories, has misplaced them, and to this date has never found them, nor served them, nor filed them, there was no activity, no action taken to progress the case forward. Under those circumstances, the trial court did not abuse his discretion in finding that unilateral, non-record activity, which didn't involve opposing counsel and didn't do anything to move the case forward, did not establish good cause for continuing this case. I'd like to inquire as to whether or not co-counsel would like to take a few of the remaining moments, and if so, ask that this court affirm the decision.
Thank you.
Thank you.
You'll know how much time. You've got about 7 minutes, but you've got a clock there that will assist you in keeping it.
Yes, Your Honor. May it please the Court? My name is Kendall Rigdon. I'm with Rigdon Alexander, and I represent the co-appellees in this case. I do want to address what seems to be the overriding concern for you, Your Honor, Judge Sawaya, on the substantive change issue. This Rule 1.420, subsection E, provides some substantive change in the law so that it should be applied retroactively. What really is the issue here is who is protected by 1.420 sub E. It is not a rule that is designed to protect plaintiffs. It is a rule that is designed to protect defendants from ongoing, lethargic, the exposure to litigation that's not being brought forward in prosecution. That's the fundamental inquiry for this court today.
Isn't it really just a rule to clear up congested court dockets and require that cases get, disposed of? I mean, I don't know that it's employed to protect either side, really. Where do you get that from?
I would respectfully disagree with that, Your Honor.
Where do you get that from?
From my application of it in the practice. There's no case law that says that.
Is there a comment to the rule?
No, sir, there is not. You're absolutely right about that. But the point of the rule is that it protects and prohibits the dockets from being clogged, which is what you're referring to. But when the dockets are clogged, it's not really, the courts have to deal with that, but the people that are exposed, that are at issue, are the defendants in these cases. So if you take the argument that's been put forward by the appellant, the only way that you can say that there's been a substantive change is if there was a substantive right before the rule was amended. There never was in the pre-2006 Rule 1.420 sub E amendment any substantive right in favor of plaintiffs or petitioners.
Well, I guess really the issue for me is when the Supreme Court says this is effective on January 1st, they could have said it's effective on January 1st as to all motions to dismiss filed thereafter, and then it would have been clear as a bell for us.
Yes, sir.
But, when they say that it's effective January 1st, it really doesn't give us a whole lot of help. I mean, in terms of activities that occur after that. I mean, what happens if you have a procedural change to the way a trial is conducted, for example? I don't know. I can't think of one off the top of my head, but how we pick a jury, for example. There's a procedural change. It would seem that the court would apply the procedure that exists at the time of the trial, irrespective of when the complaint and the answer and the notice for trial and all those pleadings were filed. Mr. Graham argues here that he is not urging retroactive application of the new rule. He's just wanting to avail himself of the right that he has under the rule applied prospectively to cure the law. What do you say about that?
Well, with all due respect, what I think Mr. Grand is
I know
arguing
that you always respect the court, so you don't need to say that.
when I disagree, I was always taught by my father that I say that, so that comes out of habit. And I don't mean to be trite, but I do mean to be respectful. in disagreeing with you, Your Honor. There has to be a point in time to determine what law is applicable. And the problem with procedural rules is that there's time periods that are relevant. The time period to respond to a complaint, the time period to file a notice of appeal to be before this court. All of those things are at issue when you comply with the procedural time period. To say that a prong of applicability is when the hearing is conducted is to now place a court with the responsibility of determining that to make sure that their hearing time becomes applicable. Those things, to the enforceability of the rule, those things do exist. The forfeiture statute, for example, there's a 10-day time period there whenever somebody requests an adversarial preliminary hearing on probable cause in which the court must avail itself within 10 days or 15 days.
Was the rule in Betts a procedural rule?
It was a substantive rule, Your Honor, because it was dispositive of the issue. And that is also the distinction that is applicable here, as opposed to the situation where we change the way in which we pick a jury, the situation that Your Honor put forward hypothetically. That's what I'm trying to get out here in probably an inartful way, is this rule 1.420 sub E is dispositive of cases. There is a substantive right.
So your argument is that the rule that we're considering today is a substantive change rather than a procedural, solely a procedural change.
No, Your Honor.
What are you saying?
I'm saying that for Mr. Graham's argument to be put forward by this court, you would have to interpret it that way in order to protect his rights.
If the rule in Betts was a substantive change and the change in this rule is a procedural change, then we can say that an argument could be made that the Betts decision doesn't apply here.
I think, yes, Your Honor. I think that the problem is that the law is very clear in how the Supreme Court puts forward these amendments to the rules of procedure. If they had intended for it to be retroactively applied, they would have clearly stated so. If they intended it to be applied to all pending cases, they would have clearly stated so. They have not done so. So to do that is to venture into the thought process, what is it the Supreme Court was trying to do here, rather than trying to apply what is, as my co-counsel
Well, we know what the Supreme Court was attempting to do here. They were doing the same thing they've done a lot of times, like, for example, in the case of state prosecutions. You used to be a prosecutor, right, weren't you?
Very briefly, Your
Well,
Honor.
they amended the speedy trial rule to give the government a right of recapture. The Supreme Court is evincing their desire to have cases adjudicated on the merits and have no gotchas when it comes to lot situations.
Yes, sir.
To give some sort of a right to cure, if you will. So I guess that's the issue in my mind, is did that right to cure spring into being on January 1st, and was Mr. Graham's client entitled to avail herself of that right?
And that is obviously the crux of the issue that's before the court today. I see that I have 21 seconds left to respond.
Well, it seems to me like the Betts decision would have been a pretty strong argument for you, but it seems to me like you may have conceded that argument when you said that there's a distinction between the rule in that case, which was substantive, and then you're conceding that the rule in this case is procedural.
No, I don't think you conceded that.
Did you concede that?
No, I'm not conceding that either.
What did you tell me then? Because I asked you whether Betts would be distinguishable. Yeah, because you indicated the rule in Betts was substantive. And in Betts, the motion and the hearing weren't filed until after the new rule became effective. In this particular case, it's the 1 year had expired. The motion had been filed under the old rule, and you're saying that the old rule and the change in the new rule is procedural. So, and then I asked you, well, would Betts be applicable to this particular case, or could it be distinguished?
He didn't, as I understand it, he did not concede that the change in the rule is procedural.
I thought I asked you, is the change in this rule procedural? And I thought you said yes. What is it, procedural or substantive?
I see that my time has expired.
Oh, I'm giving you more time.
Okay, I just want to make sure. What I was arguendo, was that in order for Mr. Graham...
My question to you is,
we're
talking about the rule in this particular case that we're considering. And you have the old rule, and then you've got the new rule. Is the new rule procedural change or substantive change? I thought you said it was procedural.
Procedural.
All right. And,
I stand corrected.
and so you're conceded that the change in the rule in Betts was substantive.
I'm saying that the bright line determination of law.
I'm just trying to determine whether we need to take Betts and apply it in this particular case. And it seems to me that if the rule in Betts was substantive and a substantive change, and the rule in this particular case is a procedural change, and there's a distinction there. And then we need to take a look at, well, does Betts still apply, or does that distinction or that change make it inapplicable? What's your position on that?
When looking at both of these decisions, they have finalized results in them. There's a finality to both of these rules here. In one situation, the liability for attorney's fees are not under a proposal for settlement. In another situation, the dismissal of a case. They're both procedural in application. So perhaps in saying that there's substantive changes, I'm not saying that there's a right to the party that's been affected, such as a civil right or something along those lines. What I mean is that there's been a finality that's determined. So I think the bright line rule of Betts should be applied in our case as well. I'm well over my time.
I'm going to give you your time and then an extra 2 minutes, so that will even you out. Okay?
Thank you, Your Honor.
You'll have actually 4 minutes.
Thank you, Your Honor. Please go. I'd like to be able to distinguish the Betts case.
You're familiar with Betts now, so you weren't before.
I'm going to try to answer Judge Griffin's question.
All right.
The rule regarding imposition of attorney's fees based on offered judgment is also statute. If the statute created a substantive right, the true rule tracked the statute, it could indeed be a substantive right. This clearly is a procedural right enacted by the Supreme Court pursuant to Article 5, Section 2, its rulemaking authority. No question about it. So whether or not that creates a vested right, I would argue no. And in the Stalinakis case, the one that the fourth DCA decided in January of this year, they pointed out that in SIA, which is a holding of the Supreme Court, case law interpreting their rule, which I'm not sure that that's any different than just the rule itself, I mean, as far as how we're supposed to deal with it out here in the real world. In SIA, they didn't limit the holding to future cases. They didn't talk about retroactivity or anything else. They just did not limit it to future cases. And the court in Stalinakis says because the Supreme Court did not explicitly limit application of its holding to future cases, we conclude that SIA applies in this case, which means the bright line rule of 30 days to file your motion for attorney fees or costs is in effect.
In this particular case, had the motion you conceded, I think the motion was filed during the time period when the old rule was effective.
Yes, sir.
And the 1 year time period had expired when that motion was filed. All right. If the hearing had been held on the day that the motion had been filed, the hearing would have been conducted under the old rule, and the case would have been dismissed.
Yes, and I wouldn't even have an argument under it.
All right. So that didn't happen, but after the new rule became effective, the hearing was held.
Right.
So then, does that make the date that the hearing is held the sole consideration that we need to take a look at?
That seems to me the date the court exercises its jurisdiction. In analogous cases, in a case called Johnson versus Moon in the briefs, where the court, in that case, the order of the motion had been filed, the order of dismissal had been had, the case had been on appeal. During the appeal, Solomon versus Wilson is decided. The appellate court said, hey, everything had been done before Solomon versus Wilson is decided, but that controls.
What about the argument that, under the old rule, that it was mandatory? If a year had expired and wasn't record activity and all the requirements were met, that the trial court had to dismiss it. It was a mandatory requirement for the trial court to do it, and the trial court merely was required to conduct a hearing to determine whether the requirements on the rule had been established, and there's nothing more for the trial court to do.
Actually, the way the old rule worked was it's not mandatory. It shifted the burden to the plaintiff to demonstrate that there was extra record activity, which would have ameliorated the effect.
So really, what the hearing focuses on under the old rule is what happened before and whether the year had expired, there was no record activity, and all those requirements had been established. And then the trial court really doesn't have any discretion. It's got to dismiss it, right?
No. It does not have to dismiss it. If, in fact, prior to that hearing, within 5 days, more than 5 days prior to the hearing, the plaintiff has filed an affidavit or a response demonstrating that there was off-record activity that would ameliorate the effects of the dismissal.
Well, let me
And he determines that here.
Okay, let me rephrase the question. When the hearing under the old rule is conducted, the trial court simply takes a look at determining whether the year had expired, the motion was filed, whether all the prerequisites for them to gain dismissal under the rule have been established. Right?
Yes, that's the
If
first
that's
thing.
the case, then the trial court has to dismiss it, right?
No.
All right.
Then the defense, in this case the plaintiff, would have an opportunity, if they followed the procedure in the rule, to demonstrate to the judge that there was extra record activity during that year, which would preclude the dismissal.
Okay, and that relates back to the year period that had expired under the old rule.
Right.
All right. And if the
We
trial
presented
court,
a case for that.
if the trial court doesn't make, if that doesn't occur, then the trial court has to dismiss it.
I suppose, yes.
So so in other
That's a
words,
discretionary decision, though, and that's judged by the abuse of discretion standard.
so I guess my question is, everything that's to be considered, during the hearing under the old rule is to be considered when, the old rule was effective, right? In other words, you're just having a hearing sometime later to determine whether everything had been complied with during the time period when the old rule was effective.
We alleged and proved by affidavit that there was an extension of
And with the
time,
exception of the affidavit.
that there was an extension of time into January 4th,
Okay.
which would have been, we would have alleged the year instead of December 30th, 29th as the year, which would have meant that it would have been filed within the year, not outside the year. So there was a teeny dispute effect.
What was the finding as to that?
There was no finding that the affidavit was incorrect. That was, in fact, there was a letter produced by the defense which demonstrated that there was an agreement to file by the 4th. It never got filed due to an error in our office. I just also would like to, if I have any time,
Just a couple seconds to wrap it up.
Del Duca, 1991 Florida Supreme Court case, had the two tests for off-record activity, whether it's sufficient. They're the only two tests. Was the non-record activity in good faith? There was never any question or discussion below that this was not in good faith. Was the non-record activity designed to move the case along? If we had actually managed to get the answers to better answers to the three interrogatories filed, it certainly would have. It's clearly designed there. That's it.
You've done over your time.
No requirement to meet with counsel or anything else.
Thank you very much for arguing on both sides.
I've seen y'all. How you doing? Nice meeting you.